Hello, everyone, and welcome to Uncivil Law. For today's case, we are dealing with a classic, Tinker versus Des Moines. This is a classic from the 1960s, dealing with free speech on elementary and high school campuses, K through 12. And in this case, someone wanted to wear a black armband to protest the Vietnam War, and the school district didn't want them to do it. And the United States Supreme Court is reviewing this and saying there is a free speech right on campuses, K through 12. It may be somewhat modified because of the educational mission of the campus, but it is not the case that students give up their right at the schoolhouse gates. So this is a classic. We are going to review this case and review what the court has to say about how speech can and cannot be restricted in K through 12 educational environments when it comes to the speech of the students attending those schools. So let's get started with this. In December 1965, a group of adults and students in Des Moines held a meeting at the Eckhart home. The group determined to publicize their objection to hostilities in Vietnam and support for a truce by wearing black armbands during the holiday season in 1965. The principals of the Des Moines school became aware of the plan to wear armbands. On December the 14th, 1965, the principals of this school district met and adopted a policy that any student wearing an armband to school during this period would be asked to remove it, and if they refused, they would be suspended until they returned to school without the armband. On December the 16th, Mary Beth and Christopher wore black armbands to their schools. John Tinker wore the armband the next day, the guy after who this case is named. They all were sent home and suspended from school until they would come back without the armbands. They did not return to school until after the planned period for wearing the armbands had expired, that is, until after New Year's Day. So the principals of this school district came into a policy, said we're going to become aware of this protest of people wearing black armbands, and anyone who does it can't come to school. And so the students did. They kicked them out and weren't able to attend school for roughly 2 weeks during the December period of 1965. The district court recognized that wearing of an armband for the purpose of expressing certain views is the type of symbolic act that is within the free speech clause of the First Amendment. So this is symbolic speech. As we shall discuss, the wearing of armbands in circumstances of this case was entirely divorced from actual or potential disruptive conduct by those participating in it. It was very close to the pure speech, which we've repeatedly held is entitled to comprehensive protection under the First Amendment. First Amendment rights, applied in light of special characteristics of school environment, are available to teachers and students. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gates. This has been an unmistakable holding of this court for almost 50 years, and again, this is righted in 1969, so add another 70 years on top of that. On the other hand, this court has repeatedly emphasized the need for affirming comprehensive authority of states and of school officials, consistent with fundamental constitutional safeguards to prescribe and control conduct in schools. Our problem lies in the area where students in the exercise of First Amendment rights collide with rules of school authorities. So here they're pointing out that schools as such have a mission and a purpose, and the free speech rights are typically analyzed under what's called time, place, manner restrictions under intermediate scrutiny. So you have free speech rights, but those free speech rights can be augmented or modified by time, place, and manner. Certain times, certain places, and certain manners. And a classic example is you might have a right to give a speech in a park, but you might not have a right to use very loud sound amplifying equipment without permission. And the reason is that if you could, you would disrupt other people in the park. The park exists for the enjoyment of everybody, and it exists for your enjoyment. So while you have freedom of speech, if you use certain sound amplification equipment without permission, it would detract from everyone's mission. The purpose of the park would be frustrated. And in the same way, the purpose of schooling would be frustrated if everyone could just engage in any kind of speech anytime under any rules. There is a fundamental educational mission for which schools are being created. And so this is a time, place, manner restriction. So on the one hand, people have freedom of speech. But on the other hand, we need to have schools existing. And if we had it completely unfettered, then schools might not be allowed to be schools. And that would be frustrating to the purpose of schools. So we have to make sure to balance these competing interests as we're looking at this in a time, place, manner type restrictions. And what times, what places, what manners. This concerns all these. We're in an educational environment. We're considering the particular manner, in this case, the armbands, and we're considering a particular time. It might be limited. So all those factors are going to go into this analysis as we consider it under the First Amendment, and also the fundamental interest of an educational environment to be able to educate. So let's read further. The problem posed by the present case does not relate to the regulation of length of skirts or type of clothing, to hairstyle, or to deportment. It does not concern aggressive, disruption, active, or even a group demonstration. Our problem involves direct, primary First Amendment rights akin to pure free speech. So again, when we're considering this, we're considering it very context, very fact specific. We're not talking about like uniforms. We're not talking about hairstyles. We're not talking about skirt lengths. We're not talking about a lot of things. In this case, we're talking about someone wearing a black armband, a very simple gesture, but one that's more akin to free speech, because there might be other things that might be more disruptive or more hostile. We're not talking about behavior of people and them sort of acting a particular way, or they're doing particular things. They're just wearing a black armband. So, if we were talking about how people conduct themselves, their deportment, if we were talking about uniforms, if we were talking about hairstyles, if we're talking about restrictions, those would all have to be considered under the fact-specific inquiry. But here we're looking at something that's much more akin to a pure free speech issue, because all it is a black armband. It's just pure symbolic speech. Very simple. So on a First Amendment spectrum kind of speech, this is more akin to the most purest form of First Amendment speech, as opposed to these other issues, which would be more muddled. Again, the muddling being influenced by the environment we're in, namely K through 12 schools. The school officials banned and sought to punish petitioners for silent, passive expression of opinion, unaccompanied by any disorder or disturbance on the part of the petitioners. Only a few of the 18,000 students in the school system wore a black armband. Only 5 students were suspended for wearing them. There's no indication that the work of schools or any class was disrupted. Outside the classroom, a few students made hostile remarks to children wearing armbands, but there were no threats of acts or violence on the school premises. So there was no actual disruption, in fact, that they were responding to. It was all hypothetical. The district court concluded that the action of school authorities was reasonable because it was based upon fear of disturbance from wearing armbands. So they said, we had this apprehension. So that made it reasonable. But the Supreme Court continues that in our system, an undifferentiated fear or apprehension of disturbance is not enough to overcome the right of freedom of expression. Any departure from an absolute regiment may cause trouble. Any variation from a majority opinion may inspire this fear. Any word spoken in class or in a lunchroom or on campus in general that deviates from the views of any other person may start an argument or cause a disturbance. So if there was any sort of disagreement at all in any sort of context, this might cause some kind of disruption. Students might have differences of opinion, and this might cause some sort of problem. And the Supreme Court continues saying that the Constitution says we must take some of this risk. And our history says that this sort of hazardous freedom, this type of openness, that is the basis of our national strength and our independence and vigor of Americans who grow up and live in a relatively permissive, often disputous society. So here the Supreme Court is saying people might have differing opinions, and they might argue about those opinions. And any sort of opinion that differs from the majority might cause some sort of disruption, or it might cause some sort of fear of the consensus being uprooted. But obviously we can't go that far. The First Amendment, by its very nature, protects unpopular opinions. So if we looked to the most extreme version of this, we're looking to the most extreme versions of this by trying to find where the line is, right? If we took the most extreme position by the school, we would take the position that any sort of opinion that counters the majority, or any sort of opinion that just counters anyone else's opinion, might cause some kind of disruption, or at least the fear of disruption. And the First Amendment says, no, we actually live in a society where people are allowed to disagree with each other. And the Constitution says we have to take the risk that this might cause some kind of disruption in the order as people are disagreeing amongst themselves. The First Amendment says it's okay. Now, again, We are looking to the fundamental purpose of schools as we are considering this. So the other extreme position isn't going to fly either. We are in an environment where there's no sort of countervailing interest. We're not in an environment where someone can engage in speech in such a way that wouldn't disrupt anyone. And we're in a place that has been constructed for a very particular purpose. So we can't take the furthest extreme position from the school, because that wouldn't make sense, because then we would just restrict all opinions, and that's not going to fly. And we can't take the most extreme position the other way, because then it would interfere with the pedagogical interest of the school. But the court is pointing out that the extremes don't really work. We have to find something that makes both these interests gel. In order for the state, in the person of school officials, to justify prohibition of a particular expression or particular opinion, it must be able to show that its action was caused by something more than mere desire to avoid discomfort and unpleasantness that always accompanies unpopular viewpoint. So you need to show something that's a little bit stronger than just there's been a mild disagreement. There might be an interest here, but you have to show a little more. Certainly, when there's no finding and no showing that engaging in the forbidden conduct would materially and substantially interfere with the requirement on an appropriate discipline in the operation of school, the prohibition cannot be sustained. So the Supreme Court is saying, yes, you have a right, you have an interest as the school to make sure that you can school. You have an interest in maintaining discipline. You have an interest in maintaining order, but you need something a little bit more than just mere concern of disruption. If you had actual evidence of ongoing disruption, if you had actual problems in the pedagogical mission of the school, that would be one thing. And if you had even a little bit more that this is just not your typical thing, that's going to be a little bit more disruptive, that might be something too. But you need something a little bit more than just the most base concerns that there's going to be a problem. In this case, the action of school authorities appears to have been based upon an urgent wish to avoid controversy, which might result from expression, even by the silent symbol of armbands or of oppression to this nation's parts in the conflagration in Vietnam. It is also relevant that the school authorities did not purport to prohibit the wearing of all symbols of political or controversial significance. So this is suggesting maybe viewpoint specific, which is also a constitutional no-no. The record shows that some students in the school wore buttons relating to national political campaigns, and some even wore the Iron Cross, which has particular symbology. The order prohibiting the wearing of armbands did not extend to these symbols, so it didn't extend to political campaigns at large or even the Iron Cross. It was only armbands. So that's a bit of a problem, because that might be a viewpoint-based discrimination. Instead, this particular symbol, black armbands wore to express opposition to Vietnam, was singled out for prohibition. Clearly, the prohibition of expression of one particular opinion, at least without evidence that is necessary to avoid material and substantial influence with schoolwork or discipline, is not constitutionally permissible. So that is another problem. You weren't trying to ban all political speech. You were doing it only based on particular viewpoints. And so we're now in perhaps a different tier of constitutional scrutiny. We are not now just in time, place, manner kind of restriction, because now we're looking to specific viewpoints. In other words, Vietnam bad. Presumably you weren't doing anything about Vietnam good. And when the government engages in viewpoint-based discrimination, that's at least strict scrutiny and might be constitutionally unpermissible completely. So we're in a whole different tier. If you had tried to ban all political speech, then that might have been different, but you didn't. And you said only the black armbands, even as you were allowing students to wear political buttons and iron crosses. And the Supreme Court says, without proof that that particular opinion was causing massive problems, you have a bit of a factual problem when you're allowing some issues but not others. That seems a little bit iffy to us, without more, and I couldn't agree more. In our system, state-operated schools may not be enclaves of totalitarianism. School officials do not pose an absolute authority over students. Students in school as well as out of school are persons under our Constitution. They are, in fact, people that have rights. They are possessed of these fundamental rights, which the state must respect, just as they themselves must respect their obligations to the state. So the state has to respect the people, and the people has to respect the legitimate authority of the state. In our system, students may not be regarded as a closed circuit representative of only that which the state chooses to communicate. They are not merely puppets. They may not be confined to expression of sentiment that are officially approved. In the absence of specific showing of constitutionally valid reasons to regulate speech, students are entitled to freedom of expression of those views. The primary use to which schools are dedicated is to accommodate students during the regulated hours for the purpose of those activities. Among these activities for the school, one of the purposes of the school is personal intercommunication among the students. This is not only an inevitable part of attending school, it is also an important part of the educational process. So one of the things the Supreme Court is saying here, that one of the purposes of school as such is not merely to provide education. One of the purposes is also to provide an environment where young children can talk to each other, to learn how to socialize. That the ability to learn how to socialize and become part of society is integrated. So the fact that students talk to each other is not a bug, as it were. It is a feature of the educational environment, that people go to learn how to be part of society by actually being part of society. A society of kids is still a society, so they are learning an important function. So these discussions that are happening by students is part of learning how to be in society. So the school looking to suppress this is actually, at least in part, a disruption of its own educational mission. Part of the educational mission is specifically to allow this type of communication. So an interesting argument from the Supreme Court, and a good point. A student's rights, therefore, do not merely embrace classroom hours. When he's in the cafeteria or on a playing field or on campus, not in a classroom during the hours he's on campus, this student may express viewpoints, even on controversial subjects, like a conflict in Vietnam, if they do so without materially and substantially interfering with the requirements of appropriate discipline in the operation of a school, and without colliding with the rights of others. So you can't be disruptive to other people. But conduct by a student, in class or out of it, which for any reason, whether it stems from time, place, or manner, materially disrupts classwork or involves substantial disorder or invasion of rights, is of course not immunized by this constitutional guarantee of freedom of speech. So here the Supreme Court is just pointing out that there is a limitation on this. And again, it's a time, place, manner type of regulation. At least in this context it is. The Supreme Court is pointing out schools have to be able to school. And so if there are disruptions that are causing material disruption, then the school has the ability to deal with those things. But they can't deal with, just mere disagreements. It requires something a little bit more. So as long as the school has the pedagogical mission, as long as the classroom environment itself, they're able to teach, so they can obviously be a little bit more strict in the classroom itself, because in that environment, that is one thing. And when it comes to outside and other activities, they can still look to the discipline of the school, but they can't go so far as to suppress speech. But it doesn't swing so far the other direction. The rights of individuals don't go so far as to be able to disrupt the primary mission of a school. And for what it's worth, this logic would apply to adults in adult environments for purposes where that would make sense. So a good example of this might be a government-owned library. A library has to be able to library. So there are freedom of speech interests, but the person can tell you to shush because it would interfere with other people's being able to read. So your freedom of speech rights are being impacted by the environment, even as an adult. And when you look to specific environments, and again, it's going to be environment specific. So whether it's schools, whether it's parks, whether it's sidewalks, whether it's libraries, whether it's a town hall, all these environments have to be able to function for their purposes. So the free speech rights of people are somewhat impacted in order to make sure that the fundamental purpose of the zone that was created for those purposes is allowed to exist. But it doesn't go so far as the government being able to impact anything. And the fact that these are children doesn't really impact the analysis. This is a school, they have to be able to school. As long as they are not interfering with the school's ability to school, the school can't interfere. If they are interfering with the school's ability to school, the school can interfere. It's basically your bottom end of the analysis on this one. If a regulation were adopted by school officials forbidding discussion of the Vietnam conflict completely, or the expression by any student opposed to it anywhere on school property except as part of a prescribed classroom exercise, it would be obvious the regulation would violate the constitutional rights of students, at least if it could not be justified by showing the student's activity would be materially and substantially disrupt the work and discipline of the school. As we have discussed, the record does not demonstrate any facts which might reasonably have led school authorities to forecast substantial disruption of or material interference with school activities, and no disturbances or disorders of the school premises in fact occurred. These petitioners merely went about their ordained rounds of school. Their deviation consisted only in wearing on their sleeve a black band of cloth no more than 2 inches wide. They wore it to express disapproval of Vietnam hostilities and their advocacy of truce, to make their views known and, by example, to influence others to adopt them. They never interrupted school activities nor sought to intrude on school affairs or the lives of others. They caused discussion outside the classroom, but no interference with work and no disorder. In these circumstances, our Constitution does not permit officials of the state to deny this form of expression. So that is the end of our coverage of the case of Tinker versus Des Moines, a classic of First Amendment law, that school children do not give up their constitutional rights at the schoolhouse gate. The school has to be able to school, but people have to have freedom of expression. That freedom of expression can pretty much go as far as it can without the interference on the school mission. And by extension, this would again apply to adults in environments where they are set up for particular purposes by the government. So libraries and parks and even streets exist for particular purposes. So people's First Amendment rights can go as far as they can without impacting the fundamental purpose for which those things were created, because otherwise the purpose for which they were created would be undermined. And so the Supreme Court is pointing out, yes, you might have a valid reason to engage in this if there were fear of actual disruption or evidence of actual disruption. But here, you didn't have that. You engaged in viewpoint discrimination without any particular reason. So you weren't able to prove that your pedagogical purpose was being impacted. And so, therefore, the regulations were invalid. A classic of First Amendment law, to be sure. And that is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.